time that I do a movie, like the first note is like in the script, in the execution, in the marketing, in the editing, they're always like, okay, we got to make sure she's likable. And I went to my husband one day and I was like, have you ever gotten the note where they like, we want to make sure this guy's likable? My husband's like, nobody's ever said that. And my husband plays deeply unlikable people, but you love him. And like women, they're like, they gotta be likable. And you're like, what is that? What does that even mean? I was lucky to be able to be involved in so many different aspects of this movie, not just on.
Hey friends, welcome back to my channel. It's Friday, February 28th, 2025. Today, I want to discuss how narcissistic individuals often misuse the court system. They tend to file unusual motions and make requests for information that they don't really need, primarily to intimidate the opposing party and increase legal costs. Essentially, they use the court as a tool to inflict more harm on their targets. Frivolous litigation is quite common, and the lawsuit involving Ryan and Blake Lively against Justin Baldoni is a prime example of this. A couple of weeks ago, they issued subpoenas to major communication companies like Verizon Wireless, AT&T, and T-Mobile, seeking over 2 years' worth of phone records. They aim to access not only the records of the parties involved in the lawsuit, but also those of third parties and anyone else they could potentially link to this so-called smear campaign. They were looking to retrieve records dating back to 2022. Justin's team pushed back, arguing that these requests were excessive and went far beyond what is permissible in civil court, especially since this isn't a criminal case. They emphasized the right to privacy and pointed out that the timelines and details they were asking for didn't add up. Blake's team, however, acted as if Justin's attorneys had no grounds to contest their demands. They acted as if they had every right to pursue this, believing that Baldoni, Wayfarer, and the other parties involved were simply trying to hide and conceal information. Just like the gig order requests didn't go their way, the subpoena also didn't favor them, and I suspect the protective order won't either. However, there's nothing quite like seeing a narcissist lose in court when the judge sees through their tactics. Today, Judge Liman granted part of the motion to quash the subpoena while denying the other part, which is relatively minor in the grand scheme of things. What he communicated to Blake and her side is what truly matters, and she was clearly reprimanded by the judge, who was visibly displeased. The dispute over the subpoena revolves around how much information she wants and the intrusive nature of the request, which seeks documents, call logs, and locations that aren't permissible in civil court. The judge ordered both parties to meet and confer to try to resolve the issues. In the court order, it was noted that after the meeting, Lively agreed to eliminate references to all documents, remove the request for locational data, and clarify that the subpoenas would only seek call logs and text logs containing non-content numerical information. Regarding the incoming and outgoing text messages, Lively has prepared and modified subpoenas to reflect recent changes. However, in a letter dated February 24, 2025, the Wayfarer parties reiterated their request to quash these subpoenas. They object to the fact that, even in their modified form, the subpoenas still cover Collins' text logs, which reveal the phone numbers of anyone who communicated with the Wayfarer parties and other individuals, regardless of whether those communications relate to the claims and defenses in this case. Consequently, the Wayfarer parties seek to limit the subpoenas to communications between the subpoenaed phone numbers and specific phone numbers of parties and witnesses that Lively would provide. Lively contends that the purpose of the subpoenas is to uncover admissible evidence regarding communications not only among the defendants, but also within the broader network of individuals involved in the untraceable campaign against Miss Lively, which justifies their wide scope. Additionally, Lively argues that the Wayfarer parties do not have standing to assert the privacy interests of non-parties. The judge will rely on Rule 26(b)(1) of the Federal Rules of Civil Procedure to make a determination on this motion. This rule states that when a non-recipient party moves to quash a subpoena based on privacy interests, the court must balance the relevance or probative value of the requested documents against the asserted privacy interests. The burden of persuasion in a motion to quash a subpoena in civil litigation lies with the moving party, who is the one making the request. Therefore, the order concludes that the subpoenas for the Wayfarer party's phone records, even after modifications made during the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain Wayfarer parties and any other phone number, primarily from December 1st, 2022, to the present. This request raises legitimate privacy concerns, even though Lively has limited her request to exclude the content of calls or messages. The phone records themselves would still contain sensitive information about which doctors, psychologists, or acquaintances the Wayfarer party communicated with and when. Lively has not identified a way to separate those numbers that may be relevant to her case from those that would not be relevant and could expose sensitive personal information. Lively mainly argues that the subpoenas will assist her in identifying the broader network of individuals who contributed to a negative media campaign against her. However, there is a footnote stating that Lively acknowledges an individual has no legitimate privacy interest under the Fourth Amendment in the numbers dialed on a phone. Nevertheless, this does not prevent the Wayfarer parties from having a privacy interest in their phone records, which, while not protected by the Fourth Amendment, may still exist under state or federal statutes or common law. The judge then references various common laws that could establish a right to privacy, concluding that a private interest exists regardless of Fourth Amendment protections. Referring back to the complaint, it states that according to Lively, this negative campaign did not start until around August 2024, with actions taken in early August marking the beginning of the plan to damage Lively's reputation. It is unclear how communications to and from Wayfarer parties in 2022 and 2023 would help identify individuals involved in the campaign. Lively has not established a sufficient basis to believe that the extensive discovery she seeks will uncover information about unknown participants in the negative media campaign, especially considering the privacy interests of the Wayfarer parties. Lively's complaint already names several individuals who allegedly took part in the negative media campaign. She is allowed to make discovery requests specifically aimed at those individuals and can use discovery tools to obtain their contact information or phone numbers. Even if there were additional participants in the alleged campaign, the expectation that discovery will yield information about them does not warrant the broad scope of the subpoenas. The subpoenas must be quashed to the extent that they request the phone records of Wayfarer parties. This ruling does not prevent Lively from serving modified subpoenas that are more narrowly focused on relevant information. The court is quashing her request for information from 2022 and 2023 because it is not permitted under the law, and she cannot use discovery to investigate whether this scheme existed prior to then. As her own complaint indicates, she believes it began in August. Additionally, they state that she cannot use this process to search for other potential participants, as that falls outside the scope of this case. She can examine the phone records of the individuals she identifies and any relevant third parties, but cannot extend her search beyond that. The situation is complicated because she lacks legal grounds for her requests, and pursuing them would infringe on others' privacy. Essentially, what he's conveying is that she has the opportunity to request and issue subpoenas, but only within a very limited context. She cannot revisit matters from 2022 or use this subpoena process to broadly search for records. Baldoni's lawyers argue that this is merely a fishing expedition. She is making claims in court without the necessary evidence and is attempting to obtain that evidence through misuse of subpoenas. Consequently, Baldoni's attorneys are leveraging the law to safeguard themselves and prevent her from misusing the court system. She will need to draft a revised subpoena that adheres to this narrow scope. The court is essentially indicating that she has misused the court system by seeking information to which she is not entitled, and her arguments lack validity and exceed legal boundaries. These individuals do have a right to privacy. What I find intriguing about their stance on privacy is that Blake asserts there is no right to privacy regarding phone numbers, claiming that no one is entitled to privacy. Yet, conversely, she argues that third parties and witnesses should have attorney-client privilege during discovery. So, when it comes to her, she demands privacy, but for others, she denies them that right. It's quite hypocritical. Additionally, there's a footnote mentioning that Lively has indicated the phone records might reveal when and how the defendants and witnesses became aware of her harassment allegations. Lively's pursuit of information in this context and its relevance to her claims hasn't been clearly outlined. The ruling here does not prevent Lively from using subpoenas to uncover specific information pertinent to her allegations of harassment and retaliation. However, It indicates that she cannot use subpoenas to find out when individuals became aware of her accusations against Baldoni and Wayfarer, as that is not part of the lawsuit. This suggests she is misusing the subpoena process, and her attorneys were justified in opposing this. One aspect that the judge did not dismiss involved third parties. It states that the Wayfarer parties have not shown sufficient standing to contest the subpoena request for the phone records of non-parties. A party can challenge a subpoena directed at a non-party by demonstrating a need to protect a personal privilege, right, or interest. While the Wayfarer parties may claim a privacy interest in their own phone records, they have not established any grounds for asserting an interest in the communications of non-parties. Consequently, the Wayfarer motion is denied regarding the portions of the subpoenas that seek the phone records of non-parties. The motion to quash is granted in part and denied in part, meaning they cannot quash the subpoenas for any non-parties involved in this case. This allows Lively to continue seeking that information, but those non-parties can file their own motions to quash. They just cannot do so on behalf of others. They also did not claim any privilege, such as spousal or doctor-patient confidentiality. In summary, Baldoni's attorneys have been quite assertive throughout this process. They are playing aggressively, employing a very strategic approach. They are up against Blake and Ryan, who have a vast network of influential supporters attempting to manipulate the media into portraying them as victims. Additionally, they're trying to frame this situation as a political issue, dividing it into left and right, which is fundamentally unjust. This matter has nothing to do with politics. It is not a Me Too conversation or politically motivated. Instead, it serves as a means to create division. What I observe in mainstream media is a clear split between those on the political left and those on the right. The right is being accused of targeting Blake and Ryan simply because they are liberal, while liberal writers from outlets like the New York Times are attempting to discredit any Republican who criticizes Blake, suggesting they oppose her due to a hatred for the Me Too movement. They are fully endorsing Blake's narrative while dismissing Justin's experiences, failing to consider what he has endured. This is not how media should operate. If the New York Times chooses to take a side and completely ignore Wayfarer's perspective, they are doing a disservice to the public. Just because a woman comes forward does not automatically validate her claims. There must be some level of evidence and an opportunity for the accused to defend themselves. When you take a stance without examining both sides, you are actively trying to influence public opinion. This is why Baldoni is suing the New York Times, although winning against such a powerful publication may prove to be quite challenging. When it comes to defamation, proving malice is quite difficult, making it a challenge in the case of the New York Times. The way they frame this as a political issue when it really isn't contributes to the division in the narrative. Honestly, it doesn't matter if you're on the left or the right. Both Blake and Ryan are liberals, just like Justin, as they are all Democrats. This isn't a matter of left versus right. Just because some right-leaning creators and podcasters, like Candace Owens, don't support her doesn't mean she is always wrong or evil. The left-leaning journalists are trying to paint Candace as the enemy simply because she disagrees with Blake. In a nuanced world, everyone is entitled to their opinions. Just as the New York Times can express its views, so can Candace. However, the New York Times is expected to report based on facts, not opinions. Whether they realize it or not, they are contributing to Blake's smear campaign against Justin. It seems they're being influenced by Blake and Ryan, only seeing their perspective and ignoring the core of Justin's case. This is a disservice to justice, as there are two distinct sides and separate lawsuits involved. You can't just accept her lawsuit as the truth while dismissing everything in his as false. Doing so means overlooking the evidence he has presented, which should be considered to evaluate her claims responsibly. That's what a diligent journalist or an informed individual would do, and ultimately, so would a jury. Everyone reporting on this should strive to maintain an objective perspective. We need to consider both sides of the story. Naturally, if you hear her perspective first, it can seem the most compelling. However, if you don't take the time to understand his side or allow him the chance to present his evidence against her claims, then you're not fulfilling your responsibility as a journalist. This is especially true for any media outlet framing this as a Republican versus Democrat issue. As a Democrat myself, I don't align with Blake and Ryan, but it's important to remember that Bon is also a Democrat. This shouldn't be reduced to a right or left issue. Those of us who support Bond or take a more neutral stance are simply stating what we observe, which may not favor her. It's crucial to base decisions on facts rather than personal feelings. At the end of the day, her ongoing misuse of the legal process, including subpoenas and protective orders, along with her manipulation of the media and her power, is the real concern. That said, it doesn't mean that Wayfarer or the set was flawless, or that mistakes didn't happen. It's important to clarify that this doesn't mean they're evil or predatory, as she hasn't provided any proof to support that claim. Additionally, we can't assume there's a smear campaign just because of what she's presented so far. She seems to suggest that Perez Hilton's attorney, Brian Friedman, who won a defamation case, is now against Blake, but Perez is simply looking at the facts. Candace Owens, being a Republican, is often viewed with skepticism, which is a bit of a red herring argument. Sure, Candace might get some things right and some things wrong, but politically that shouldn't influence how we view this case. Even Candace has mentioned that this case isn't really about politics. It has the potential to unite both sides. Many see it as a David and Goliath scenario, where a powerful entity is trying to crush the underdog, and most of us instinctively want to support that underdog. If the underdog has substantial evidence that clearly counters the claims against them, and insiders are talking to the Hollywood Reporter and Deadline confirming the situation, it adds weight to their side. Insiders have even indicated that Sony wasn't on her side, despite issuing a statement claiming they would produce 12 films for her. The situation is quite telling, especially considering that the CEO at Sony who made that statement has since resigned. He had been with the company for about 8 years and was already on his way out when he made those comments. His departure had been in the works for 2 years, so when he speaks right before leaving, it feels somewhat irrelevant. He had nothing to lose. Interestingly, this same CEO also pointed fingers at the media for the failure of his films, claiming that negative reviews were to blame for poor sales. It seems like Sony is reluctant to take responsibility for producing a subpar movie and instead shifts the blame onto the media for not liking it. If they want to avoid critical reviews, they should focus on making better films. Similarly, if they want to improve their marketing, they need to enhance their strategies. My attorney once mentioned in a filing that if you don't want to be reported on for engaging in scandalous or unflattering behavior, then simply don't engage in such behavior. It's not fair to blame the media for reporting on your actions. In this case, Blake and Ryan shouldn't point fingers at Justin and Wayfarer for the backlash stemming from their own unflattering and dismissive marketing campaign. The responsibility lies with them, as Justin's approach to marketing the film remained consistent throughout, while they were the ones who made last-minute changes without consulting anyone. And that's on you, because you missed the mark. The judge is also aware of your actions and your misuse of the court system. Justin and his team are gradually dismantling the lawsuit that Lively filed against him. I'd love to hear your thoughts in the comments below. Also, 60% of you watching my videos aren't subscribed. Please check to see if you're subscribed. It's completely free. Don't forget to click the bell icon to turn on notifications for my posts. I'm really enjoying all the comments and hearing your opinions, whether we agree or not, so share your thoughts below. Thanks so much for watching. Bye, guys.